And I'll go one further and I'll say this. I don't believe that a crime has been committed in any of these cases for any of these nurses. Juries get it wrong. Behind every miscarriage of justice, there's a jury that found them guilty. Juries get it wrong.
Nurse Lucy Letby is the most prolific serial killer of children in modern British history. However, ever since her conviction for murdering 7 babies and attempting to kill 6 more, there have been a growing number of people who are questioning the case and raising concerns about her conviction. Most notably, a featured article in the New Yorker magazine published in 2024 titled "Did She Do It?" by writer Rachel Aviv questioned Letby's conviction, raising concerns about the evidence relied on in the case. And so in this episode, we'll be examining the Letby case with criminal barrister Mark McDonald. Mark is a hugely experienced criminal barrister and has worked on many high-profile trials, and continues to be involved in a number of high-profile appeals against conviction, including that of Ben Geen, a nurse who, like Letby, was convicted of murder, and of which there are now serious concerns being raised about his conviction. I started by asking Mark whether it was right to say that the evidence against Letby was mostly circumstantial, and how this compared to other cases involving nurses.
Yeah, so all, certainly in my knowledge, have been cases where someone has looked back on what they perceive to be incidents with patients. And sometimes they can be weeks, sometimes it can be months, sometimes it can be years, that they're looking back and saying, well, look, in my view, something has gone wrong here. And then they've sort of joined up the dots to say, well, this is what I think has taken place. At the time, generally, they've considered it not to be any form of intentional harm or indeed reckless harm against the patient. Some of it have just been natural deaths or natural phenomena that have happened that have caused the patient to go in one particular way or another way. But in hindsight, they've said, actually, we think this is what's taken place, and it's that nurse that's done it. So that's generally there's no evidence. There's no evidence from a witness that says I saw that person hurt that patient. It's just really they were there at the time and their behavior may have been a bit bizarre. And the key to this, the key to all these cases, and you cannot separate Colin Norris, nurse convicted of murder, Lucy Letby, nurse convicted of murder, Baby, nurse convicted of murder, Lucy Letby, nurse convicted. You cannot separate any of those cases because they all follow very similar patterns.
And on the deaths themselves, so this was presented to the jury that the deaths in this case were statistically significant, that the babies were dying kind of at an extreme rate due to, something or someone. But there are issues with relying on these type of statistics in these cases, aren't there?
And this is the biggest concern. I think there are 2 main concerns. One that we're probably going to come on to later, which is the nature of what is an expert. And that type of evidence going before the jury, what I would refer to as anecdotal evidence, suddenly becoming great, getting far more weight and becoming expert evidence. And it's secondly, what they being the prosecution rely on an issue of what they call a pattern. And it sounds quite compelling when you first hear it, which is this patient has become ill and no one knows why. The same person is on duty each time one of these patients become ill, which no one knows why they become ill. And the nature of the illness is really rare. So they go, look, rarity, unexplained, and that person's on duty. There's a pattern. Members of the jury, and they go through the shift of the particular nurse, and they go through the patients, and they put together this pattern, and they say, that's it. And it's fait accompli almost in the presentation to the jury. The problem with that is if you take a step back and you work out, in fact, that statistically, the nature of the illnesses that have happened, it's not a rarity, and there is an explanation, and actually it happens when that person's not there as well. But to do that, you have to take an analysis across the health service, not simply on one particular unit between a set period of time, and that's never done. And that's the problem, that without actually having a proper statistical basis for something, what you're getting is anecdotal stuff. You know, you're getting someone saying, I've never seen that before. Well, that's really rare. It must be that something wrong has happened. And that's what's leading to, in my view, wrongful convictions. So one has to be careful in relation to shift work, one has to be careful in relation to rarity, one has to be careful in relation to pattern, because like I did with Benguin, you can dissect it down and you can get statisticians to come in and say, you know what, this is a complete fallacy. It's not true. And when you break down the pattern, then you realize, in fact, if you take away the pattern, they have nothing. Then that's when you get down the path of a miscarriage of justice taking place.
And I guess that kind of that plays into this timesheet that was presented to the jury. So this was the timesheet that showed that Letby was the only nurse who was on duty at the time of these unexplained deaths. But that timesheet itself only tells a limited picture, doesn't it, to the jury?
It's a bit like, it's probably not the best analogy, but it's a bit like, you know, your friend says to you, oh, I bet you I can on the side of that shed from 100 meters away, I can fire dead in with my gun into the center of the bullseye. And be, oh no, you couldn't do that. He said, I could do it. He said, okay, do it. So he sprays the side of the shed with a machine gun with 100 bullets, walks up, and then paints a bullseye around one of them. Says, there you go. That's what's happened. And that's the danger in this, is taking a sort of a point of time, painting a picture around it, and saying, there you go, that person must have been responsible for the deaths or the injuries of patients. And it's deeply concerning. And you'll have a whole series of statisticians saying, sort of pulling their hair out, saying, this is just pure madness. You can't run a trial like this. You can't convict people like this. So it's something that's, again, that is mirrored throughout all the nurse cases, is an issue of confirmatory bias, i.e. you only look at the patients that you know that the nurse is on duty for. And you disregard the patients where that nurse is not on duty. And so for example, in this case, I think initially there were 30 patients that may have been identified and 15 that were put forward. Now, what we don't know is, of the ones that were disregarded, whether or not they were ever looked at again by an objective person, by somebody that didn't know that somebody was under suspicion, that may have been that she was not on duty at that moment in time. And I think even that there were times when, in this case, where she was on duty, but she may not have been there when the thing happened that caused the patient to die, the baby to die, or the baby to get ill.
So one other area on this case I wanted to ask Mark that I didn't quite understand when I was following it is, why did the defense not call any medical experts?
All right. So I don't know the way that the defense run this case. I am not privy to the privileged information that they had, and indeed if they'd approached others. I can only speak about cases that I have been involved in.
Mm.
And one of the difficulties that we have in the United Kingdom is the fact that many uh, uh, doctors will not give evidence for the defense in cases involving child abuse. Simply can't find them. If you are charged with an offence that involves an injury to a child, be it a baby shaking type injury, or indeed intentionally harming a child, like Lucy was charged with, there are very few doctors in this country willing to put their head above the parapet and actually work for the defence. And the reason why is because historically they have been attacked by the establishment. And I don't mean that in some sort of conspiratorial sort of raid type establishment. I'm talking about being reported to the General Medical Council and being struck off. And it happened to a very well-renowned pediatric neuropathologist at the John Radcliffe Hospital in Oxford. She took the view that the whole theory that the prosecution had been running for a number of decades in relation to baby shaking was in fact flawed. The research that they were relying upon was flawed. And she started giving evidence for the defense and saying that there was an alternative theory here. And she was destroyed. She was taken to the GMC. She had a 3-month trial. She was convicted by the GMC. It was overturned in the Court of Appeal, but she never worked again.
Mm.
And that's one of the problems. And other medics see what took place, what happened to her, and simply no longer want to do it, want to get involved. And so you have to go overseas. You have to go to America. You have to go to Canada. You have to go to Europe. And now there's actually books being written in relation to the difficulties and the problems that you face in the United Kingdom, giving evidence, and that there are a whole series of medics and scientists across the world recognizing that there's a huge problem, not with giving evidence in the United Kingdom, but with issues in relation to baby shaking. So you now have a problem that you can't find people, or you go to somebody and they just agree with the prosecution. Go to someone in England and they just agree with the prosecution, so you can't use it. So there's no one there you can use. If I am ever faced with this type of allegation from the point of view of as a barrister, and what I'm going to do, I just simply won't go to anyone in England. I'll go overseas. Now, I do not know whether the defence team did that. They may have done. I don't know. But what I do know is that they didn't have anyone to call to rebut. But I know of numerous doctors and scientists across the world, particularly in the United States, that are saying that the science that was used, particularly in the Letby case, was not sound. And it's deeply concerning. And actually, I've been contacted by a number of doctors, particularly neonatologists in this country, that are saying that there's something wrong here. There's something terribly wrong here. And taking the view that Lucy Letby is a wrongful conviction.
And isn't that just massively concerning from a justice perspective? Because what chance do the defense have in this case? You know, the defense can't call medical experts, and the prosecution has them lined up to you know, as you said, maybe give their anecdotes of what their experience is on this.
Yeah.
How can the jury be presented with a fair trial?
Well, they can't. what you will have is that you'll have a person arrested and interviewed, but before they are charged, the police and the prosecution have all the time in the world, I mean years, to put together their expert evidence. And then once they've got all their that's in a row, they charge. And you'll go to court, and then there'll be a timetable set down for trial. And in that timetable, you have the defense have to get their experts. And sometimes it takes a long time to find an expert. I did a trial once, and all my experts were from overseas in a child abuse case. And before, in a preliminary hearing, the judge said to me in open court, "Why is it that you're using experts from overseas? Is it because you couldn't find anyone in England to agree with you?" And that's the attitude that you take, that you face. And here's one of the other difficulties: because they're given evidence from New York, are you going to fly them over? Probably not. That means they've got to give evidence for a video link, which is not as persuasive as the person from down the road who's just getting in the witness box and able to give evidence. So that's just start of the problem. The other problem that I face is that some of the experts that are being called, the quality of the expert evidence, and I caveat it by saying I don't even think it's expert evidence that's being given. It is so poor that it's actually hard to challenge. If I say to you, I got on the train this morning, and there was a person in a wheelchair on the carriage, and goodness me, I have never seen that before. How rare is that? Every day I get on the train at 8 o'clock, and I haven't seen a person in a wheelchair on the train before. And as a consequence, I don't see any reason why we should spend money adapting our trains, because I've never seen anyone. And I saw one, and that was it. So why am I spending millions of pounds? Now you've got to challenge me on that. And the way you challenge me, of course, is you say, "Well, other people have." And you say, "Well, what other people? Where are they?" And so unless you actually go out there and actually get the other people to say it, or we go back to our statistical evidence, what you find is someone giving anecdotal evidence, that I've used before. And the whole basis of it's one, it's hard to challenge by simply saying, "Well, how can I challenge your experience?" Two, there's no research or literature review on it. But here's the problem that we have in this country, already in every country. These are doctors giving this evidence. It's anecdotal evidence.
Right.
And that's the danger in this case, because so-called experts are being going into the witness box and giving evidence not on any basis of research that they have undertaken, but on a basis of anecdotal evidence. In my experience, it doesn't happen. That's what's convicting these nurses. And you, like I, and maybe a little bit more different now in sort of post-pandemic world, but we were brought up to believe that if the doctor said it happened, that's what we did. If the doctor told you to take the pill, you took the pill. That's the end of it. And so this medic would go into the witness box and say, "I'm a doctor. I've been a doctor for 20 years now. I've never seen this happen before." And so what am I going to do? Am I going to go to America and call a doctor that says, "Well, actually, I've seen it happen"? What's the quality of that evidence to the jury? I mean, how overwhelming is it that they're hearing someone say, "I've been a doctor for 20 years and I've never seen it happen"? And so you get, and that comes back to this issue of rarity or unexplained. And then they point to the person in the dock and they said, that's because that person did it. And these are what this is, the ground, the solid towers to which these convictions. I have a client that's going to spend the rest of his life in prison based upon that evidence. And I'll go one further and I'll say this. I don't believe that a crime has been committed in any of these cases for any of these nurses. And I speak for the ones that I've looked at and researched and the one that I've represented. And it just seems bizarre that let me use a term that we now hear a lot. Once you see it, you can't unsee it. Once you realize that there's a problem here and the reason why there's problems there, you just can't get out of your head because you realize, you can see how these things happen. I see cases going to court on baby shaking, for example, where the defense have not called any experts. Imagine waking up one morning and finding your child is dead in the cot, and then calling the ambulance, calling the police, and the police arriving, and you're arrested for it. They said, yes, no, we've done a post-mortem on this child, and we've taken the view, the doctors have taken the view this child's been shaken. And suddenly you're still mourning for the death of your child, and now you're in a police station, and now you're being charged, and you've got all these experts who say, well, I haven't hurt my child, I've never touched my child, and now you're convicted, and now you're spending life in prison.
I wonder, Mark, if we can look at the kind of other evidence that was presented to the jury in this case. So one of the pieces that the prosecution went on was this large amount of medical documents that were found in Lucy Letby's house. Hundreds of medical handover notes, and this was kind of presented to the jury as evidence that something was wrong here. She was keeping documents that she shouldn't have been, perhaps as a trophy of the murders. How strong evidence is that to say she had documents at her house and therefore she did it?
It's not, in my view. But again, and I caveat this, I was not involved in this trial.
Yeah.
I was not part of the defense team. And so it's difficult for me to comment upon the weight of any particular piece of evidence. But the same happened, for example, in Bangui. At his house, they found stuff that was from the hospital where he lived. Now, it may be unusual. It may be a bit where you shouldn't really take stuff from work home with you. Yeah, there may be a data controlling issue going on here. It could be a number of things, of innocent explanations behind it. Does it make you guilty of murder? No. But what it does do is that it allows the prosecution to attack your credibility. It allows the prosecution to say, and particularly in the case of Bangui, this is the one that I'm speak from authority on, it allows the prosecution to say, well, they're just odd. They're just wrong. And you know what? They're probably called another nurse to say, well, we wouldn't do that. Oh, that's not what we would have done. Well, that was wrong. And suddenly the picture that they're painting of you is somebody who is in disgrace. And that's the way that you collapse. You destroy the credibility of the individual that's on trial, and then you get the anecdotal evidence that you called, and then you get some well, not even a statistic, because there's no proper statistical basis to any of this, but you assert a statistic by saying, oh, this is all so never happened before, and boom. And then actually what you get are patients who have suffered, patients who may have died. And so you've got this strong element of emotion in there. And then you've got that person did it, individually. And it's deeply concerning.
And it's one of those things, as you say, where particularly in cases like Letby's, where the public want a prosecution, they want somebody in jail for it. And I found the reporting on the Letby case really quite interesting, because a lot of it just seemed to have a presumption of guilt throughout it.
But that goes with a lot of cases, I have to say. You know, I've been involved in miscarriages of justice for the last 25 years. And the reporting around many of the cases that I've been involved in has been incredibly prejudicial, has been incredibly one-sided. I know during a trial, my own experiences, the press will turn up on day one of the trial. The prosecution will do the opening speech, and they will then report, it was said in courts today that this person did this murder by stabbing that individual, whatever it may be, whatever that case will be. And then the media will disappear. And so you'll have this whole prosecution case outlined in the news, outlined in the newspapers, then you won't see them again until the person is convicted, and then you'll go, and now they're being convicted of the crime, or in the alternative, they're found not guilty, and you never see the press. You actually see the press talking to the prosecuting counsel, talking to the police. The Court of Appeal have said over and over again that a person can still receive a fair trial, even though unfair press intervention has been so prejudicial against the defendant that it's obvious that they can't receive a fair trial. The Court of Appeal have said they can. And I give you a case in point, a guy I've represented now for 20 odd years, a chap called Michael Stone. Right off subject a little bit, but Michael Stone was convicted of the most horrendous murder that took place in 1996. It was all over the media.
I can remember it, yeah.
And a year later, Michael Stone was arrested and was put on trial. And, you know, when he was arrested, he was the police worked with the main, I think it was BBC and ITV, and they were actually there when he was brought into the police station. They were filming the car because they were all told about it. Almost like what happened with Cliff Richards. You know, that the BBC knew about it and they had helicopters and all the rest of it. That happened with Michael Stone. And that was, his credibility was destroyed. The newspapers and newspaper reporters were going to the area and paying local people, prostitutes, drug addicts, for information to which they were being put on. So his conviction was then overturned, and he had to have a retrial. And there were thousands of articles and news programs destroying him, and he had to have a retrial in that environment. And he was, of course, convicted again. I mean, you know, and in the Lucy Letby, it was appalling, the media surrounding her. You know, and she's had a retrial on one of the counts, and she's probably the most talked about person in this country.
And the idea that juries are supposed to disregard this is just ridiculous, right?
It's just disingenuous rubbish.
Yeah. I've Mark, one of the things I've read, and you'll tell me how true this is that if you think your client did it, you don't put them on the stand. And the defense put Letby on the stand for several days to defend herself and give evidence. Is that true? If the
No,
if the
no,
defense
no,
thought you might no?
no, 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 no. And so there sometimes if you're charged with an offence, um, there comes a stage where it is actually, as a defence barrister, probably the most difficult decision you have to make throughout a trial. Do you put your client into the witness box? And just a clarification, in the United Kingdom, we don't call it the stand. The stand is an
Sorry.
American term.
Too
It's
much American drama. Yeah.
I tell you, they creep into our lexicon all the time. No, it's in the witness box.
Yeah.
Into the witness box, and we and you know you spend days talking to your client sometimes about it, because of course when a defendant or an accused goes into the witness box, it's all very well talking to me. So I'm going to say, like, Mr. Smith, so tell me what happened on that day. And they say, well, I got up in the morning and this happened, and then I did this, and then I did that, and I went home, and I just don't know what they're talking about. The police go, well, thank you very much for telling the story. I'm going to sit down now. And then the prosecution get as much time as they want, rightly so, to literally hammer home their case. Explain this. Well, what were you doing here? And what did you say about that witness who said that you were over there? And what do you know, just completely. And unless that person can stand up to the pressure, the question you've got to ask yourself as a defense barrister is, have you done sufficient damage to the prosecution case up to the point that the defendant goes into the witness box?
Right.
So if you feel that actually you can do your speech to the jury without calling your client, then you think, well, why do I need to put them up there to make the prosecution case stronger? There's an old term that we use, that, in essence, that the prosecution case was really weak, but it only got stronger when the defendant ran into the witness box.
Yeah.
And that's not because the defendant is guilty. That's because they're unable to withstand sometimes very aggressive cross-examination from a prosecution counsel who may have been doing the job for the last 30 years and be very skilled at being able to make you look guilty, as much as a defense barrister will be very skilled when they cross-examine a prosecution witness in actually destroying the prosecution case. So will the prosecution case get stronger if you put the person in the witness box? And are you able to say to the jury, without putting your client in the witness box, actually the prosecution case is so weak you can't convict? So that's a decision you've got to make. The fact is, you don't know what the jury's thinking, so you don't know. And in this country, you don't have the right to silence. So the jury are actually told, if you don't go into the witness box, members of the jury, she didn't go into the witness box, and therefore you can hold that against them. You can't convict wholly upon that, but you can ask yourself, members of the jury, why didn't they go in the witness box? Is that because they don't have a defense to answer to this? And so, and I paraphrase a very detailed direction that they're given, but in essence, that's what it is. There is no right to silence. And so you've got to factor that in your decision. So no, the fact of whether you think they did it or didn't do it is absolutely irrelevant. Question is, have you managed to damage the prosecution case so sufficiently that you don't need to call your client. And when I say damage, that doesn't mean that you've uh, misled the jury by being very clever. It means actually the prosecution case could have been very weak. It wasn't the case to answer. So why call your client just to let the prosecution make their case stronger for your client?
And I guess either way, you have to be a particularly strong person to withstand
Oh yeah.
that, and to withstand and to go against all of the medical experts that have been called and all of the evidence that's been, twisted, presented against you. It's an incredibly difficult task.
And what you've got to remember, and it's very easy to forget this, certainly from a jury point of view, it's not the question, it's the evidence. It's the answer. All right. So I say to you, how could it possibly be the case that the time that you are on duty, each time, and you go through the whole of the prosecution case in a question, how could that possibly happen? And the answer is, I just don't know. Now, that's not the witness accepting the prosecution's question. But what the jury here is that the whole premise of that question, and then a witness going, well, I have no explanation for that. And they're going, yeah, that's because you did it. So they have no choice but to put Lucy Letby on the witness box. But that meant that the prosecution case was going to get stronger. And every question that she's going to be asked, to which she had no explanation to. And it may be because there was no explanation. And it may be because the whole premise of the prosecution's case was built upon the straw of anecdotal evidence and weak circumstantial evidence.
It's really interesting. And then on the other evidence that was presented against Letby in this case, the documents that were found at Letby's address, and in particular, the prosecution pulled out this now infamous post-it note where she wrote, "I killed them on purpose because I'm not good enough. I am evil. I did this." How strong is this as evidence of guilt?
Well, first of all, let me start with this premise before I go on to the detail.
Yeah.
In each nurse case, they have found something to be able to undermine the credibility of the individual that's on trial, so they can destroy them right from the beginning. This sort of smoking gun. On its own, it's nothing. It will never convict her. But from a point of view of the other evidence that I've talked about, the pattern that is as a fake pattern, the experts that come and give evidence, which in fact are anecdotal and are all doing it in hindsight. Remember that each child that died and each child that suffered at the time was ruled to be natural, that not ruled to be suspicious at all. Yeah. So it's all done in hindsight. But roll back a second. Let me answer your specific question. That note, remember, it is a piece of paper, has lots of jottings on from memory.
Yeah.
Not all written at the same time. It's almost scribble that she's writing down. It's almost a stream of consciousness that she's doing down. It's all done after she's been arrested, after she's been interviewed. I think maybe after she's been charged. I'm not too sure about that, but certainly whilst this investigation is going on. And it can be read, and it has been read by senior criminologists as not saying, I did it, but almost saying, with this pressure upon her, with the police investigation on her, with almost saying, you did it, you're responsible. And she's saying, did I do it? Could I have done it? And did I? Because in that note, it's also contradicting itself. It's also saying, did it, or did I do it? It's her questioning her actions, which may be perfectly legitimate, but she's being told that she's a killer. Being She's being interviewed and being said that she's been a killer. She's in the newspapers being saying that she's a killer. And and she's now questioning herself in that stream of consciousness. Let me put it this way. If she was guilty, if she was the manipulative, clever, sophisticated individual that they say that she was, she's going to leave a note out on saying that she did it. When in her bedroom she has a shredder that she could have shredded the paper with. You don't do that. This is a stream of consciousness from an individual who is questioning herself and what she may have done. As I say, on its own, it would not have gone anywhere.
Letby's appeal was refused.
Yes.
I'm assuming this is exactly what you were expecting.
Oh, yes.
Yeah.
We haven't read the judgment yet, so it's very difficult to see. Reasoning is it's been embargoed because of the retrial. That it's very rare that the Court of Appeal overturns a jury conviction. You know, there's an interesting story I heard. Chris Mullen, who was a great campaigner and has written a number of books, still alive today, and a great person. He was a Labour MP, actually. He did a lot of campaigning work as a journalist on the Birmingham Six. And the Birmingham Six actually went to the Court of Appeal 3 times, and their convictions were maintained twice, I think, by the Court of Appeal. It's only on the 3rd time that they were overturned. And it took years to get them back to the Court of Appeal. And each time he went to the Court of Appeal, each time the issue arose, he'd go around the studios saying, I think these guys are innocent. And a very famous retired judge would sometimes go on the TV, a chap called Lord Denning, that you may have heard of. And he told us of a time when he was in the back of a cab going between the BBC and the ITV studios with Denning. And Denning said to Chris in the back of the cab, and Denning was going on television saying, well, you know, the jury's convicted them. There's a lot of evidence. It's been through the Court of Appeal. They've had all this. Therefore, you know, these are convictions that need to be upheld. And Denning said to Mullins, they're innocent, aren't they? And Mullins nearly fell off the seat in the back of the cab and said, yes, why don't you say that? And he said, because it wouldn't be worth the destruction of the criminal justice system to allow this conviction to be overturned. Because it was at the time the biggest miscarriage of justice that the country had had. Imagine a Court of Appeal overturning the longest criminal trial in history, the most spoke about case that we know, certainly in my time as a barrister. Said to be the murder of a number of babies, and the Court of Appeal saying these convictions are unsafe. Imagine the damage that would do to the criminal justice system, to the jury system, to the prosecution, to the police.
It's
yeah.
No, and so are there any other legal routes open for Letby and her legal team now, or is this it?
So the Criminal Cases Review Commission was set up actually after the Birmingham Six. Birmingham Six, it used to be that once you were convicted, because you can only go to the Court of Appeal once. Once you were convicted, and you've gone to the Court of Appeal, they've maintained it, they've upheld the conviction, that you would have to go to a minister and convince a minister in the government to refer it back to the Court of Appeal. And that's what the Birmingham Six did. When Birmingham Six were eventually freed and found that it was a massive miscarriage of justice, the then Home Secretary stood up in the House of Commons, a chap called Michael Howard, and said that from now on, we're going to take it out of the hands of the government and of ministers. It's going to go to an independent body called the Criminal Cases Review Commission, and that was set up to investigate potential areas of miscarriage of justice or simply that convictions were unsafe. The problem is, since then, it's been so poorly funded that it takes years to go through, and sometimes, actually quite common, the people that are looking at the cases are not trained or not able to see um, uh, um, some of the real problems and issues that have taken place in trials. So they don't send cases back to the Court of Appeal. They make mistakes, and it takes many years for it to happen in any event.
Mm.
And so I would say that Lucy Letby will end up on the table of one of the people who works for the CCRC, and it will be probably another 5 to 10 years before, if it gets back to the court.
Mm. And in that time, there have been, there's obviously the New Yorker article that's come out as well, questioning the statistics that were relied on this case and questioning the conviction. There does seem to be, and I'm sure you've had nurses, doctors contact you. There does seem to be a sense of unease amongst many about Letby's conviction.
There will be, in the next year or so, I think, a number of documentaries on television.
Mhm.
I think she's innocent. There will be other journalists. I know one in particular who's done a lot of work on this case, who will publish an article as soon as the retrial. Right now, you can't say anything.
No, we
Uh,
can't broadcast this till
we
after.
can't
Yeah.
broadcast this. We all know that until an order is in place or an order is removed by the trial judge saying that we can have a discussion around the case, then we can. The New Yorker article is being banned from the United Kingdom. You can't get it at the moment by order of the trial judge. And so once all that is gone, then all the discussion that has been rated to have, that we've been waiting to have on this case, will be allowed to happen. Now, changing the narrative, as I call it, in relation to these big cases takes a long time. And, in the case of Michael Stone, I've worked on changing the narrative now for the last decade, and it will change with Lucy Letby. And when the time is right, she will go back to the Court of Appeal. And when the right evidence has been put in place, that from the defence side, to be able to challenge the evidence that was pulled by the prosecution, I hope that it will be found, as I think it is, as all the cases of nurses before her, I have seen that evidence has been presented to say they're innocent and the conviction will be unsafe. And so, some people say, well, jury trials, well, they've been put in front of a jury. The jury have found them guilty. Juries get it wrong. Behind every miscarriage of justice, there's a jury that found them guilty. Juries get it wrong. Juries get it right. Jury system is the best system we have. They get it wrong. We have democracy in our country. That doesn't mean that people don't vote for the wrong people, because they do all the time.
And that's it's very interesting, Mark, because there'll be some people who say that that the case should be done now, that the parents who tragically lost their babies, the conversation we're having is not helpful for them. They want justice. They want and they want somebody in prison. So what's your kind of reaction to that claim?
Well, I mean, it's horrendous, isn't it? Because these people have been told that the people that they love so much and cherish in life were hurt or died at the hands of an individual who intentionally meant it to happen. And then they were put in trial and were found guilty of doing it. For someone like me to come along and go, oh, I'm not too sure that that's a safe conviction, they're going to be angry, and rightfully so. The real question is, are they being angry at the wrong white people? You know, the case of the Birmingham Six, a case that is still going on today. In the background, there are a lot of victims of that awful crime that are still seeking justice. And they're very angry about what took place. The problem, it's not a great analogy because, again, with the Birmingham Six or with Michael Stone and the Russell murders, people were killed and were murdered. In these cases involving the nurses, there's an argument, and a strong argument, to say there was actually no criminal activity at all here. And in fact, the patients were very poorly indicted. Or, as we have found now, and look at the Offaldon review into the state of maternity services, actually, our health service in relation to neonatal care, pediatric care, and obstetrics in certain units are simply not fit for
purpose. Mark, was there? Did you have any final thoughts or anything else you wanted to share with us on this case or the other nurse trials you've worked on? It's been incredibly interesting and getting your insight on it. I think the thing that's struck me listening to you is how similar they all seem to be, how they're all based on this statistical basis that may or may not be true. Yeah. Then there's a bit of character destruction, and there you've got your conviction.
Yeah, and all done in hindsight, and actually all done with very poor science behind them as well. There's I don't think there's anything I need to add except to say this. What we call an expert in this country, the threshold for calling yourself an expert is so low that you know a police officer who watches a CCTV is able to identify a perpetrator from it. It's called an expert when they're no more than you and I. A doctor who says, this injury was caused by this action happening, is not an expert. They're a doctor. An expert is somebody who has published material on a particular subject, who has research and an evidential basis. But we have people going before our jury systems day in, day out in this country that are called experts, and they're not. That whole area needs to be challenged. Second, the Court of Appeal is the test for overturning the conviction is wrong and needs to be relooked at. There's too much subjective nature of, you may have a great ground of appeal, one that you think should blow this conviction out of the water, but the judges are allowed to say, but we think the conviction is still sound, it's still safe, even though you've made a good point on the argument. That's wrong.
Mark McDonald, thank you so much for joining us. Thank you for your insights. By the time this interview is broadcast, reporting restrictions will have been lifted, so there will be a discussion taking place about Letby, about the trials. So I hope that we managed to help contribute to that discussion. Mark, thank you very much.